Now let's study Chapter 3 of the Companies Act 2013, Prospectus and Allotment of Securities. It has two parts. Part 1 about public offer. Public offer and private placement. A public company may issue securities to public through prospectus, herein referred to as public offer, by complying with the provisions of this part, through private placement, by complying with the provisions of Part 2 of this chapter, or through a rights issue or a bonus issue in accordance with the provisions of the Act, and in case of a listed company or a company which intends to get its securities listed, also with the provisions of the Securities and Exchange Board of India Act 1992 and the rules and regulations made thereunder. A private company may issue securities. So far we looked how shares are issued in a public company. In a private company, the shares may be issued by way of rights issue or bonus issue in accordance with the provisions of this Act, or through private placement by complying with the provisions of the Part 2 of this chapter. Explanation. For the purpose of this chapter, public offer includes initial public offer or further public offer of securities to the public by a company, or an offer for sale of securities to the public by an existing shareholder through issue of prospectus. Section 24 states about the power of Securities and Exchange Board to regulate issue and transfer of securities. So SEBI is a regulatory body. It regulates the issue and transfer of shares. Shares are also called as securities. The provisions contained in this chapter and Chapter 4 and in Section 127 shall, in so far as they relate to issue and transfer of securities and non-payment of dividend, by listed companies or those companies which intend to get their securities listed on any recognized stock exchange in India, except as provided under this Act, be administered by the Securities and Exchange Board by making regulations on this behalf. So when a company wants to issue, the company has to follow the LODR, and in any other case be administered by the central government. Explanation. For the removal of doubts, it is hereby declared that all powers relating to all other matters relating to prospectus, return of allotment, redemption of preference shares, or any other matter specifically provided in this Act shall be exercised by the central government, the tribunal, or the registrar, as the case may be. The Securities and Exchange Board shall, in respect of matters specified in subsection 1 and the matters delegated to it under provision 2, subsection 1 of section 458, exercise the powers conferred upon it under subsections of the SEBI Act 1992. Document containing offer of securities for sale is to be deemed prospectus. So such document is called as deemed prospectus, where a company allots or agrees or to allot any securities of the company with a view to all or any of these securities being offered for sale to the public, any document by which offer for sale to the public is made or shall be made for all the purposes be deemed to be a prospectus. So note the word deemed to be a prospectus issued by the company, and all enactments and rules of law as to contents of prospectus and as to liability in respect of misstatements. So when a company issues a prospectus inviting public to subscribe for the shares, it should keep in mind that all the rules of law, enactments, the liability in respect of misstatements, or if any omissions or any errors of commissions is in prospectus, shall apply with the modifications specified in subsection 3 and 4 shall have effect accordingly, as if the securities had been offered to the public for subscription, and as if persons accepting the offer in respect of any securities were subscribers for those securities, but without prejudice to the liability if any of the persons by whom the offer is made in respect of misstatements containing in the document or otherwise in respect of. For the purpose of this Act, unless the contrary is proved, be evidence that an allotment of or an agreement to allot securities was made with a view to the securities being offered for sale to the public, if it is shown that an offer of the securities or of any of them for sale to the public was made within 6 months after the allotment of agreement to allot, that at the date when the offer was made, the whole consideration to be received by the company in respect of the securities had not been received by it. Section 26 as applied by this section shall have effect as if it required a prospectus to state in addition to the matters required by that section to be stated in a prospectus. The net amount of the consideration received or to be received by the company in respect of the securities to which the offer relates, by the time and place at which the contract whereunder said securities have been or to be allotted may be inspected. The persons making the offer were persons named in a prospectus as directors of a company. When a person making an offer to which this section relates is a company or a firm, it shall be sufficient if the document related to in subsection 1 is signed on behalf of the company or firm by 2 directors of the company, or by not less than 1/2 of the partners in the firm, as the case may be. According to section 26, matters to be stated in prospectus. Every prospectus issued by or on behalf of a public company, either with reference to its formation or subsequently, or by or on behalf of any person who is or has been engaged or interested in the formation of a public company, shall be dated and signed and shall state the following information, namely, name and address of the registered office of the company, the name of the company secretary, the CFO, Chief Financial Officer of the company, auditors, legal advisors, bankers, trustees, underwriters if any, and such other persons as may be prescribed. The dates of the opening and closing of the issue should be clearly stated in the prospectus. And declaration about the issue of allotment letters and refunds within the prescribed time. So in the prospectus, a proper declaration should be given about the issue of allotment letters and the refunds within the prescribed time. Next, a statement by the board of directors about the separate bank account where all the monies received out of the issue are to be transferred, and disclosure of details of all monies, including utilized and unutilized monies out of the previous issue in the prescribed manner. So all the money which is collected from the issue of shares, initial public offer or further issue of shares, the money which are collected is deposited in a separate bank account, and it should mention how the money is utilized or unutilized in the prescribed manner. Details about underwriting of the issue. The shares are given to underwriters for underwriting, then the details should be stated in the prospectus. Consent of the directors, auditors, bankers to the issue, expert opinion, maybe a legal opinion, if any, and of such other persons as may be prescribed. The authority for the issue and details of the resolution passed thereof. A proper resolution should be passed for the issue of shares. Next is the procedure and time schedule for allotment and issue of shares. Procedure and time schedule for allotment and issue of shares. The capital structure of the company in the prescribed manner. Main objects of the public offer, terms of the present issue, and such other particulars as may be prescribed. Main objects and present business of the company and its location, schedule of implementation of the project. Particulars relating to management, perception of risk factors specific to the project. Gestation period of the project. So you have to mention about the risk factors of the project, gestation period of the project, extent of progress made in the project, deadlines for completion of the project, and any litigation or legal action pending or taken by a government department or a statutory body during the last 5 years immediately preceding the year of the issue of prospectus against the promoter of the company. Minimum subscription, amount payable by way of premium, issue of shares otherwise than on cash. Details of directors, including their appointments and remuneration, and such particulars of the nature and extent of their interest in the company as may be prescribed. Disclosures in such manner as may be prescribed about sources of promoters' contribution. Set out the following reports for the purposes of the financial information, namely reports by the auditor of the company with respect to its profits and losses and assets and liabilities, and such other matters may be prescribed. Reports relating to profits and losses for each of the 5 financial years immediately preceding the financial year of the issue of prospectus, including such reports of its subsidiaries and in such manner as may be prescribed. Provided that in case of a company with respect to which a period of 5 years has not lapsed from the date of incorporation, the prospectus shall set out in such manner as may be prescribed. The reports relating to the profits and losses for each of the financial years immediately preceding the financial year of the issue of prospectus, including such reports of its subsidiaries. Reports made in the prescribed manner by the auditors upon the profit and losses of the company for each of the 5 financial years immediately preceding issue and assets and liabilities of its business on the last date to which the accounts of the business were made up, being a date not more than 180 days before the issue of the prospectus. Provided that in case of a company with respect to which a period of 5 years has not lapsed from the date of incorporation, the prospectus shall set out in the prescribed manner the reports made by the auditor upon the profits and losses of the business of the company for all financial years from date of its incorporation. Usually, the financial data for 5 years are put in the prospectus, whereas if the company is incorporated and has not completed 5 years, they put all the information up to the period they have completed from the date of incorporation. Reports about the business transaction to which the proceeds of the securities are to be applied directly or indirectly. Make a declaration about the compliance of the provisions of this Act and a statement to the effect that nothing in the prospectus is contrary to the provisions of this Act, the SEBI 1956 and the SEBI Act 1992. So, as per Securities Contract Regulation Act and Securities and Exchange Board of India Act and the rules and regulations made thereunder, and state such other matters and set out such other reports as may be prescribed. Noting, nothing in subsection 1 shall apply to the issue to existing members or debenture holders of a company, of a prospectus or form of application relating to shares in our debentures of the company, whether an applicant has a right to renounce the shares or not under subclause 2 of clause A of subsection 1 of section 62 in favor of any other person, to the issue of prospectus or form of application relating to shares or debentures which are or are to be in all respects uniform with shares and debentures previously issued and for the time being dealt in or quoted on a recognized stock exchange. Subject to the provisions shall apply to prospectus or a form of application whether issued on with reference to the formation of a company or subsequently. Explanation: the date indicated in the prospectus shall be deemed to be the date of its publication. No prospectus shall be issued by or on behalf of a company in relation to an intended company unless on or before the date of its publication there has been delivered to the registrar for registration a copy thereof signed by every person who is named therein as a director or a proposed director of the company or by his duly authorized attorney. A prospectus issued under subsection 1 shall not include a statement purporting to be made by an expert unless the expert is a person who is not and has not been engaged or interested in the formation or promotion or management of the company and has given his written consent to the issue of the prospectus and has not withdrawn such consent before the delivery of a copy of the prospectus to the registrar for registration, and a statement to that effect shall be included in the prospectus. Every prospectus issued on the face of it state that a copy has been delivered to the registrar as required under the provision. Specify any documents required by this section to be attached to the copy so delivered, and refer to statements included in the prospectus which may specify these documents. The registrar shall not register a prospectus unless the requirements of this section with respect to its registration are complied with, and the prospectus is accompanied by the consent in writing of all the persons named in the prospectus. No prospectus shall be valid if it is issued more than 90 days on which a copy thereof is delivered to the registrar. So the company must ensure that a copy of the prospectus and consent in writing of all the directors and proposed directors be sent to the registrar before issuing it. No prospectus shall be valid if it is issued more than 90 days after the date on which a copy thereof delivered to the registrar. If a prospectus is issued in contravention of the provisions of this section, so the company should make sure that it meets out all the provisions required in drafting a prospectus. When it contravenes, the company shall be punishable with a fine which shall not be less than 50,000, which may extend to 3 lakhs. And every person who is knowingly a party to the issue of such prospectus shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, or with both. Imprisonment which may extend to 3 years, or a fine which may vary from 50,000 to 3 lakh rupees, or with both. Variation in terms of contract or objects in prospectus. A company shall not at any time vary the terms of contract referred to in the prospectus or objects for which the prospectus was issued, except subject to the approval of, or except subject to an authority given by the company in general meeting by way of special resolution, provided that the details as may be prescribed of the notice in respect of such resolution to shareholders shall also be published in the newspaper, one in English and one in vernacular language, in the city where the registered office of the company is situated, indicating clearly the justification for such variation. Provided further that such company shall not use any amount raised by it through prospectus for buying, trading, or otherwise dealing in equity shares of any other listed company, the dissenting shareholder being those shareholders who have not agreed to the proposal to vary the terms of contract or objects referred to in the prospectus shall be given an exit offered by promoters or controlling shareholders at such exit price, and in such manner conditions as may be specified by the SEBI by making regulations on this behalf. According to section 28, offer of sale of shares by certain members of company, where certain members of a company propose in consultation with the board of directors to offer in accordance with the provisions of any law and for the time being in force whole or part of their holding of shares to the public, they may do so in accordance with such procedure as may be prescribed. Any document by which the offer of sale to the public is made shall, for all purposes, be deemed to be a prospectus issued by the company, and all the laws and rules made thereunder as to the content of the prospectus, and so as to liability in respect of misstatements in an omission from prospectus or otherwise relating to prospectus shall apply as if there is a prospectus issued by the company. The members, whether individuals or body corporate or both, whose shares are proposed to be offered to the public, shall collectively authorize the company whose shares are offered for sale to the public to take all actions in respect of offer of sale for and on their behalf, and they shall reimburse the company all expenses incurred by it on this matter. Public offer of securities to be in dematerialized form. Notwithstanding anything contained in any other provisions of this Act, every company making public offer and such other class or classes of public companies as may be prescribed shall issue the securities only in dematerialized form by complying with the provisions of the Depositories Act 1996 and the regulations made thereunder. So that's the reason in bank we had to open a demat account to hold the securities in electronic form, not in materialized form, in dematerialized form. And the Depositories Act 1966 governs the activities of such electronic shares. Any company other than a company mentioned in subsection 1 may convert its securities into dematerialized form and issue its securities in physical form in accordance with the provisions of this Act, or in dematerialized form in accordance with the provisions of the Depositories Act 1996. Advertisement of prospectus. When an advertisement of any prospectus of a company is published in any manner, it shall be necessary to specify therein contents of its memorandum as regard the objects. So the object clause in the memorandum becomes very important when it comes to prospectus. The liability of members, the amount of share capital of the company, and the name of the signatories to the memorandum, and the number of shares subscribed by them, and its capital structure. According to section 31, shelf prospectus, any class or class of companies as the Securities Exchange Board may provide by regulations in this behalf may file a shelf prospectus with the registrar at the stage of the first offer of securities included therein, which shall indicate a period not exceeding 1 year as the period of validity of such prospectus. So shelf prospectus, the validity period is not exceeding 1 year, which shall commence from the date of opening of the first offer of securities under that prospectus, and in respect of a second or subsequent offer of such securities issued during the period of validity of that prospectus, no further prospectus is required. So shelf prospectus validity period is more when compared to red herring prospectus. A company filing a shelf prospectus shall be required to file an information memorandum containing all material facts relating to a new charge is created. The charge is created. Changes in the financial position of the company as have occurred between the first offer of securities or the previous offer of securities and the succeeding offer of securities, or such other change as may be prescribed. So apart from initial public offer is known as first offer of securities, further offer of securities, or can also be termed as succeeding offer of securities, and such changes as may be prescribed with the registrar within the prescribed time prior to the issue of a second or subsequent offer under the shelf prospectus, provided that where a company or any other person has received applications for the allotment of securities along with the advance payment of subscription before the making of any such change, the company or other person shall intimate changes to such applicants, and if they express a desire to withdraw their application, the company or other person shall refund all the monies received as subscription within 15 days. So refund should happen within 15 days. Where an information memorandum is filed, every time an offer of securities is made under subsection, such memorandum together with the shelf prospectus shall be deemed to be a prospectus. For this purpose, the expression shelf prospectus means a prospectus in respect of which securities or classes of securities included therein are issued for subscription in one or more issues over a certain period of time without the issue of a further prospectus. According to section 32, red herring prospectus, a company proposing to make an offer for securities may issue a red herring prospectus prior to the issue of a prospectus. A company proposing to issue a red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and the offer. A red herring prospectus shall carry the same obligations as applicable to a prospectus, and any variation between the red herring prospectus and a prospectus shall be highlighted as variations in the prospectus. Upon the closing of the offer of securities under this section, the prospectus stating therein the total capital raised, whether by way of debt or share capital, and the closing price of the securities, and any other details as are not included in the red herring prospectus shall be filed with the registrar and the Securities and Exchange Board. For the purpose of this section, the expression red herring prospectus means a prospectus which does not include complete particulars, of the quantum or price of the securities included therein. Issue of application form for securities. No form of application for the purchase of any of the securities of a company shall be issued unless such form is accompanied by an abridged prospectus, provided that nothing in this subsection shall apply if it is shown that the form of application was issued in connection with a bona fide invitation to a person to enter into an underwriting agreement with respect to such securities in relation to securities which were not offered to the public. A copy of the prospectus shall, on a request being made by the person before the closing of the subscription list and the offer, be furnished to him. If a company makes any default in complying with the provisions of this section, it shall be liable to a penalty of 50,000 rupees for each default. Criminal liability for misstatements in prospectus. Where a prospectus issued, circulated or distributed under this chapter includes any statement which is untrue or misleading in form of context in which it is included, or where any inclusion or omission of matter is likely to mislead. So any inclusion or any omission of any matter which may mislead every person who authorizes the issue of such prospectus shall be liable under section 447, provided that nothing in this section shall apply to a person if he proves that such statement or omission was immaterial and he had reasonable grounds to believe and did up to the time of issue of prospectus believe that the statement was true or the inclusion or omission was necessary. civil liability for misstatements in prospectus. Where a person has subscribed for securities of a company acting on any statement included or the inclusion or omission of any matter in the prospectus which is misleading and has sustained any loss or damage on a consequence. As a consequence thereof, the company and every person who is a director of the company at the time of the issue of the prospectus has authorized himself to be named and is named in the prospectus as a director of the company or has agreed to become such director either immediately or after an interval of time, is a promoter of the company, had authorized the issue of the prospectus and is an expert referred to in subsection 5 of section 26, shall, without prejudice to any punishment to which any person may be liable under section 36, be liable to pay compensation to every person who has sustained such loss or damage. No person shall be liable under subsection 1 if he proves that having consented to become a director of the company, he withdrew his consent before the issue of the prospectus and that it was issued without his authority or consent, or that the prospectus was issued without his knowledge or consent, and that on becoming aware of its issue, he forthwith gave a reasonable public notice that it was issued without his knowledge or consent. Notwithstanding anything contained in this section where it is proved that a prospectus has been issued with intent to defraud the applicants for the securities of the company or any other person or for any fraudulent purpose, every person referred to shall be personally responsible without any limitation of liability or for any of the losses or damages that may have been incurred by any person who subscribed to the securities on the basis of such prospectus. Punishment for fraudulently inducing persons to invest money. Any person who either knowingly or recklessly makes any statement, promise, or forecast which is false, deceptive, or misleading, or deliberately conceals any material facts to induce another person to enter into or to offer to enter into any agreement for or with a view to acquiring, disposing of, subscribing for, or underwriting securities. Any agreement for the purpose of pretended purpose of which is to secure a profit to any of the parties from the yields of securities or by reference to fluctuations in the value of securities, or any agreement for or with a view to obtaining credit facilities from any bank or financial institution shall be liable for action under section 447. Action by affected persons. A suit may be filed or any action may be taken under section 34 or section 35 or section 36 by any person, group of persons, or any association of persons affected by misleading statements or inclusion or omission of any matter in the prospectus. Punishment of personation. Personation for acquisition. Punishment for personation for acquisition. Any person who makes or abets making of an application in a fictitious name to a company for acquiring or subscribing for its securities, or makes or abets making of multiple applications to a company in different names or in different combinations of his name and surname for acquiring, subscribing of its securities. Otherwise, induces directly or indirectly by a company to allot the registrar by any transfer of securities to him or any other person in a fictitious name shall be liable for action under section 447. Provisions of subsection shall be prominently reproduced in every prospectus issued by a company and in every form of application for securities. Where a person has been convicted under this section, the court may also order disgorgement of gain, if any, made by seizure and disposal of securities in possession of such person. Amount received through disgorgement or disposal of securities under section 3 shall be credited to the Investor Education and Protection Fund. Allocation of securities by company. According to section 39, no allotment of any securities of a company offered to the public for subscription shall be made unless the amount stated in the prospectus as the minimum amount has been subscribed and the sums payable on application for the amount so stated have been paid to and received by the company by check or other instrument. The amount payable on application on every security shall not be less than 5% of the nominal amount of the security or such other percentage or amount as specified by SEBI by making regulations on this behalf. If the stated minimum amount has not been subscribed, the sum payable on application is not received within a period of 30 days from the date of issue of prospectus or such other period as may be specified by SEBI, amount received shall be returned within such time and manner as may be prescribed. So, on issuing a prospectus, if a company couldn't get enough subscribers, the minimum amount is not subscribed within a period of 30 days from the date of issue of the prospectus, then the company has to refund the amount in the manner as prescribed. Whenever a company having a share capital makes an allotment of securities, it shall file with the registrar a return of allotment in such manner as may be prescribed. In case of any default under subsection 3 or subsection 4, company and its officer who is in default shall be liable for a penalty for which 1,000 for each day during which such default continues or 1 lakh whichever is less. Securities to be dealt with in stock exchanges. Every company making public offer shall, before making such offer, make an application to one or more recognized stock exchange or exchanges to obtain permission for the securities to be dealt within such stock exchange or exchanges. Where a prospectus states that an application under subsection 1 has been made, such prospectus shall also state the name or names of the stock exchanges in which the security shall be dealt with. All monies received on application from the public for subscription of the securities shall be kept in a separate bank account in a scheduled bank and not to be utilized for any other purpose other than adjustment against allotment of securities where the securities have been permitted to be dealt within the stock exchange specified in the prospectus. For the repayment of monies within the time specified by the Securities and Exchange Board received from applicants in pursuance of the prospectus, company is for any other reason unable to allot securities. Any condition purporting to require or bind any applicant for securities to waive compliance with any of the requirements of this section shall be void. If a default is made in complying with the provisions of this section, the company shall be punishable with a fine which shall not be less than 5 lakh rupees but which may extend to 50 lakh rupees. And every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000 rupees but which may extend to 3 lakhs, or with both. A company may pay commission to any person in connection with the subscription to its securities subject to such conditions as may be prescribed. Global Depository Receipt. A company may, after passing a special resolution in its general meeting, issue depository receipts in any foreign country in such manner and subject to such conditions as may be prescribed. So let's look part 2, private placement, in the next video. Thank you.